Good morning, everyone, and welcome. I'm Lou Pierro. This is Frank Hemming. If you've seen the Medicaid Mondays before, you'll know which is which. And we're very happy to be here today to talk about nursing home Medicaid. And this is our current roster of attorneys. And we are primarily in two locations, Albany and New York City, but we have other locations throughout New York State, Garden City, Lake Placid, Hudson, and a few other affiliated offices in Massachusetts, Connecticut, New Jersey, and Florida. Our primary practice areas are estate planning and elder law and everything that spins off of that. And we'd like to start out this morning, or this afternoon, I should say, with an update. And this is something that you all need to be aware of. And Frank, tell our guests what we've got.
So unfortunately, it's not great news. I mean, it's nice that they are all with us and it's nice that we have news to report. Unfortunately, just not positive news. And that's that the implementation of the requirement that home care people, right, those seeking Medicaid at home, now they will be required to need assistance with at least 3 activities of daily living instead of the 2, which has been for a very long time. And that this increase is set to go live as of September 1 of 2025. So in just about 6-7 weeks time, this will be the new reality for people getting home care. So when they do their medical assessments, now that will be looked at whether they need assistance with at least 3 activities of daily living instead of 2, or if they have an Alzheimer's or dementia diagnosis, they'll require supervisory assistance with at least 2 ADLs, where that had previously been 1 ADL. So this has been upped from 2 to 3 and then 1 to 2 for the people with cognitive deficit. And this was all passed back in 2020 during all the things that happened during COVID. So we've been very fortunate that they have not been implementing these potential changes all this time, but unfortunately now this is now going to be here. This is going to be the new reality. So we wanted to make sure that everyone out there was aware of this change, because this might mean the difference of somebody getting services or not, depending on when they apply. So if someone's on the fence, try to get their app in no later than next month, if possible.
We'll be covering the topic in depth on August 11th, so we hope you can join us then. This has been a steady progression in New York State, going from the assessment rules and the NIA assessment and having a independent physician panel, not having any access to your own doctor. So New York has made it harder to get Medicaid home care. This is another shot across the bow. Now we have 3 ADLs as one of the requirements. We probably are going to try to bring in a care coordinator or care manager who has experience in going through the Medicaid application process and those NIA assessments, which is where this new rule will be applied. And we certainly follow NILAG and Valerie Bogart's team and how they are assessing and looking at this. And Valerie kind of threw something out there, and that is that we haven't had the 2.5-year look back period yet. Hasn't really come around. But now that New York State is implementing this, she just put the headlights on and said, look ahead, this may be coming. And you might have heard that a big, beautiful bill passed in Washington, D.C. with almost $1 trillion of Medicaid cuts. We will be following that, analyzing that. We won't know what the true impact is on New York State till next year, but you know it's going to have an impact. It's going to cut programs and services. And so stay tuned, stay with us. Today's topic, though, is Medicaid for the nursing home. We're going to do a quick recap of income and resources, exempt assets, how to get yourself eligible for Medicaid for the nursing home, what happens if you've done no planning, how do you use things like promissory notes, how do you use spousal refusal, and how do you take steps now to plan in advance for that nursing home care. And the cost of care, these might seem low based upon what we have been hearing and getting feedback from our clients who are going into nursing homes and having the kids coming in with the bill. Okay, here it is. It's $18,000 a month. That's not easy to tolerate or palate, but it's something that is reality. And in New York City, obviously, it's a little bit more expensive. Long Island is a little bit more expensive. So it depends on where you are in New York State as to the cost. These numbers have been with us since January. And Frank?
So biggest number here that's meaningful for today is that bottom number, which is the $50 of your allowance when you're in the nursing home. The others, obviously, we saw slight increases for this year. So again, if you're a single person, it's $18.20 per month of income. If you're a couple, it's $24.53 for income. And then if you're a spouse, meaning your spouse needs Medicaid, right? If you're the well spouse, you can get $39.48 of income every
Yeah.
month.
That $50 a month has been with us for a very long time, as far as I can remember back, and I've been doing this for 42 years. And so there is legislation that was proposed to up that number. I don't think that has passed yet, but we'll follow up. Hopefully that will get through, because that is an artificially low number and you can't afford to get your hair cut and do anything else in the nursing home with that $50. And of course, then we have to worry about assets.
Right, and these are a little bit more meaningful for today's discussion. So resources or assets, again, single person, it's $32,396, so up just about $1,200 from last year. If you're a couple, it's $43,781. And then if you're that community spouse, again, where your spouse is receiving services, you are not, then the lower tail is $74,820. The upper tail is now up to $157,920. So again, good news, slightly better than last year, but still not a lot of money.
Far more complicated than it needs to be. They froze that 74,820 back when Governor Pataki was governor. And then they allowed the increase only if the couple's resources were twice what that number amounted to. So that is not like any other state. Most other states have different fixed. We're lucky we have two numbers to deal with, depending upon the assets of the married couple. But most other states have just one. The high limit is the federal limit, 157,920. Some states adopt that, others have lower limits. So know what state you're in New York, you have to do a calculation with regard to the married couple. And not all assets count against that 32,396, right?
Right. So first off, you get your allowance. So you get 32,396 or less. So if all you have is 30 grand and that's it, then you're eligible. You can have a prepaid burial amount in any amount that you want. So this could be a lot of money, it could be a little bit of money, but as long as it's prepaid and it's in an irrevocable funeral arrangement, that is also an exempt asset. If you have an income producing asset like a business, the business itself is exempt as an asset. You can have a very small amount of life insurance. So if its face value is less than $1,500, then your life insurance is exempt. The big one that we constantly, I think, give counsel to people more than anything else, where it comes as a surprise to the client about it not counting, is that IRA. So if you have an IRA or other tax deferred retirement account, if it's in payment status, then it is exempt as an asset. This also has so far in our practice included Roth IRAs as well. And you can have one car regardless of its value. So anything else other than those things listed on the screen likely will count as an asset.
And that's your favorite asset to counsel clients about, right?
The car?
The car.
Yeah, buy a Lamborghini. It's fine. You can have it. You can see it out your window. You can wave to it. You maybe can get a ride in it, but you can have one car.
So keep these in mind. The IRA, major exception, life insurance, not even worth talking about. Income producing assets, business, not many people have an active business, but what about rental real estate? Is there a way that you can take rental properties if a client has rentals and turn them into a business? And we typically form a limited liability company. We do an operating agreement, we run it as a business, and then when you apply, you want to have that LLC be the asset that's being reported. And there is a set of regulations that govern this. They're federal regulations. I actually did a presentation for the National Academy of Elder Law Attorneys on it. And you can qualify assets as businesses if they produce regular, steady streams of income. In fact, in Florida, if you end up with a client who goes to Florida, there is a company, or two companies actually, who have bundled rental real property, and you can actually buy into those bundled properties. So you're not an active property manager, and take what are non-exempt liquid assets and put them into what becomes exempt rental property. That's Florida. Could you do the same thing in New York? If you qualify it as an active business, you could, but this is going to take more management because no one has basically created an industry for this yet. So when we look at the other main asset that most clients have, and most clients come into us with a major IRA, 401k, and a home. And Frank, the home gets special treatment.
It does. So first thing is we have to look at if there's anyone in the house, because if your spouse is in the house, you have a minor or disabled child in the house, then the house is exempt. It doesn't count as an asset. Unfortunately, there are many people when they come in where they just have themselves. They don't have a spouse any longer. They don't have any disabled children or minor children in their life anymore. So for many instances, while there are ways of protecting the house, it's not always the case for every single client that comes in. But there are some other exemptions that we use sometimes. So like a caregiver child, where they provided care for at least 2 years prior to institutionalization, we sometimes use that one. If it's the rare instance where a sibling has an equity interest and they've had it for longer than a year, you can transfer the remainder interest to the sibling. Obviously, if you have a disabled child, if they don't live in the house, you could always transfer to a disabled child. Or again, if you have that spouse, you can either transfer the house can just reside in the house. That would exempt it as well. But that kind of only usually kicks the can down the road because if something happens to the spouse in that instance, well, now you have a new problem because now your house is back on the table for problems down the road.
Yeah. So we look at in the first instance, the main thing is to get all of the facts, get the income, the assets, the family situation, who's living in the home, what are the parameters in terms of retirement accounts, IRAs, Roth IRAs. All of those facts and details are extremely important. And the first thing we do, Frank, is counsel clients on the spend down.
Yeah.
What can you legitimately spend to take those assets over the 32,396 and spend them? And it has to be spent on the individual who's applying for Medicaid in some fashion.
Mm-hmm.
You don't want to go have 4 TVs appear as an expense. We had a client that did that and came in and said, well, I applied and they rejected me because we bought 4 TVs. Yeah, 3 of those are transfers.
Yeah.
I'm only using 1 TV. So you have to be smart about this, but you can preserve a lot of assets and resources by fixing up the home. Putting in a new roof. If the home is exempt, then you have to put a new roof on the house, or you need to do the sidewalks. You can put money into the home, and it is not a transfer. It's investing in, if you will, in an exempt asset. So once you get done taking everything off the top that you can, prepaying funerals and burials, and you can do more than the clients.
Yeah. So if you're not eligible yet, you can spend down on prepaying burials for other people. It could be siblings, it could be children, it could be other people, it could be in-laws. Weirdly enough, the statute is quite broad here. So sometimes, while it may not be the most fun thing to talk about, sometimes we do have people spend down on funerals and burial agreements for the other family members because at least that's doing work for the family instead of just handing it essentially to Medicaid or the nursing home.
And my favorite recommendation for Christmas gifts for all of my clients applying for Medicaid are to go out and buy your son-in-law a funeral. Send a good message. So we are looking at chronic care Medicaid now. Again, community Medicaid has different rules. We're waiting to see on the 30-month look back. We don't know what's coming there, but we don't have any look back right now. So we're not talking about a look back period. And Frank, briefly, when you apply for Medicaid, we need all of the facts in terms of the assets, but we need more facts for 5 years.
Yeah, so we also need we need to document what your current income is. And then the counties also like to see things like your tax returns. They like to see if there were other assets that were producing income to make sure that we've allotted for all of those statements for any closed accounts or anything else that comes up. So it's not just your bank accounts. It could be, and just to be clear, it's all your financial assets. So it's not just bank accounts. It's stock accounts, brokerage accounts, 401ks, life insurance, pretty much anything you likely could think of. That's what requires the 5 years of financial audit.
And it's a full audit. There are a lot of people out there doing Medicaid applications that don't necessarily know all of the nuances of these rules, don't necessarily do a full 5-year audit, and that puts the client at risk because if things pop up that are things that they didn't even think about that were unintended transfers that happened during the course of that 5-year time period, they're going to come back and they're going to present problems at the point of Medicaid application.
Right. So like paying for college for a child or a grandchild. It's what if you just gave your car to somebody because you couldn't drive it anymore? What if you make large donations to your church or other charities? These are all kinds of things that likely would be flagged and penalized by a Medicaid office. So what we like to do is do the audit up front, get out in front of the issues, and then work with the family on how best to solve them, whether there's money that can be returned, whether there's kind of a story that could be told to explain why it wasn't a gift. There are several ways of kind of dealing with this. It's just a matter of knowing about it up front before the county gets a hold of the documents, and then we're kind of playing defense rather than offense.
And the exceptions are major exceptions. You can gift an unlimited amount of assets to a spouse. And we're going to talk towards the end of the program about spousal refusal, because you can load up the healthy spouse with assets. They can sign a spousal refusal, apply for Medicaid for the ill spouse, and get that ill spouse qualified. There are consequences to that, but it gets immediate Medicaid eligibility, and the consequences are not so bad in most cases. The other that often gets overlooked, and we've had this case where it didn't come up, they didn't put it in our questionnaire, and we have a very thorough questionnaire that actually asks this question: are there any children with disabilities? Because you can also gift an unlimited amount of assets to a child with a disability. Now, again, nuances and some complexities, because if that child is also on SSI and Medicaid, you have to make sure the gift qualifies and doesn't kick them off their benefits, but there are ways to do it. But you can gift assets and create Medicaid eligibility immediately by gifting them to a disabled child. And the home also has qualified beneficiaries that can receive it as a gift.
Yeah, biggest thing here again is you want to make sure that you're not solving one problem and then creating another problem for the beneficiary. So it's usually a tool that we like to have in the toolbox, and sometimes we use it, sometimes we come up with a different scenario or a different way of dealing with it. But it's just good to know that it's there.
And Frank, you mentioned the penalty period.
Yeah.
Most people don't realize that, 5 years is a look back, but there's a penalty period as well. How does that work?
So essentially, the numbers now on your screen are the divisors. These are what are called the Medicaid regional rates for 2025. So essentially what happens is Medicaid will take a look at your audit. They will figure out how much money has been gifted or missing or transferred, however you want to look at that. And then they take the total amount of money that's gone and they divide it by the penalty number, that penalty divisor for the region in which you're applying. So for Albany, the capital district, our number is 13,916. So essentially for every $14,000 that's missing, it equates to 1 month of penalty. And we're going to go through this a little bit more in just a minute.
So wherever you are in New York State, and I know we have people from all across the state attending today, check out your regional rate. That's the divisor. Plug that into the equation. How much money was gifted? Divide it by this number, and that's the number of months of ineligibility. So Frank, let's dig into this example.
Right. So right here, we found in this example, if there was $166,992 missing, if they do the math for the Albany area, right, the capital district, you do the math and it comes out to 12 months. So for giving away $166,000 plus, right, and then applying to Medicaid, if you're in that 5-year period where those transfers occurred, that would result in 1 year without Medicaid, meaning that person's going to be in the nursing home, but Medicaid's not going to pay for that. So the only question then is, do they have the assets and the resources then to pay through the penalty? But if you're applying for Medicaid, well, you only have $32,000 or less, or you wouldn't be applying for Medicaid. So that's why the penalty is so dangerous, because you might not have really any money remaining because you spent it or you gifted it away, but then you get hit with this penalty period.
So these rules came in 2006. It was a change that was designed to basically curtail Medicaid planning. And we had to go to work and work around these rules, because it used to be that you could do something called a rule of halves or a half a loaf transfer. And you could gift half the assets, keep half the assets, pay the nursing home as the penalty period wound down, and then apply for Medicaid. But you don't get to do that anymore, because you have to be in the nursing home and otherwise Medicaid eligible, then file your Medicaid application, which means at the start of the penalty period, you have to be below the $32,396. So how do you do this? And there are a number of my colleagues from the New York State Bar Elder Law section that went out and litigated cases. We did a couple of our own on promissory notes. Others litigated annuity cases, and we found a safe harbor through that litigation. And that is the promissory note plan.
Yeah, or the rule of half, we call it rule of halves, half a loaf, promissory note, and gift. It has many names, but essentially the concept is that we take about half of the assets and we gift them away. We take the other half of the assets and we loan them away. And as long as it's done properly, the promissory note has not been deemed to result in either a penalty period or count as an asset. And then that's designed to pay during the penalty period. So on the very next slides, we're going to walk you through what this actually looks like. Because these are just words. This is hard to follow. This gets in the weeds. So we're going to do our best to simplify this. So we have Bob, right? He comes in, he's got some income every month. So he's got over $2,000 a month of income. He's got $400,000 of assets. And he hasn't made any large gifts in the past 5 years because he heard that wasn't a good idea. So Bob didn't do that. He's already in the nursing home. It's costing him $16,000 a month. The family wanted to spend down some of his money on some, things that he needs: television, clothes, furniture. Pays us, right, the legal fee for the attorney. So they spent him some money. And then essentially, then we're going to do our calculation. We're going to give some money. We're going to loan some money. And again, we're going to have a slide that lays out kind of like exactly what this looks like and the result here. But essentially, he comes in, he's got some money, we spend him down, we do the calculation, and then we save about half the money doing all this.
And the Medicaid Asset Protection Trust has been the subject of other Medicaid Mondays. You can go back on our website and see the list of topics, including the full discussion of the Medicaid Asset Protection Trust. We use it in most cases because it keeps control of the money, keeps access to the money. And Frank, these calculations don't always go as planned. Things happen.
No, unfortunately. I've had cases before, like where when the county does their asset verification, they found an account that no one knew about, and that kind of throws everything off. That happens. The other thing that happens more with these that kick them out of whack is somebody winds up going to the hospital, right? And their cost of care changes, then their income's involved. Their cost of care isn't as much as their income now. That can create some issues. But hopefully, as long as you have all the information, this tends to go pretty well.
Yeah, they may get Medicare coverage for 30 or 60 days, which kind of the promissory note is paying in
Right.
where there are no expenses.
Right. So things get a little messy.
Yes.
So just to kind of put numbers to this. So again, so right up top, we looked at Bob's income. So he gets $2,000.50 per month. He's allowed $50 as an allowance. So he has $2,000 to play with. That's his net available income for this purpose. So he's got a nursing home cost of $16,000 per month. He can pay two of it on his own through his income. So he's short $14,000 a month. His assets, he started with $400,000. We spent down 34 on his television and his other things and his legal fees. And then we want to earmark some money to stay with Bob, because again, to be on Medicaid, he can have some money, he just can't have very much. So we're going to say, well, let's leave him with $30,000. We're going to leave him about $3,000 short of his allowance. So that means we've got $336,000 to play with. So if we do the math, you take 336, you cut it in half, and we have a gift and a loan, each for half. So $168,000 to each side. So on that left side, your gift, you gave away $168,000 to the family. You then do the calculation. That results in a 12-month penalty.
And that's being held again in a Medicaid Asset Protection
Right.
Trust.
That's all going to his trust, where then it's protected. It's off the table, right, from further issues, and it's there to make sure it's there for the family or for Bob. So we've got 12 months of penalty because we gifted away 168 to his trust. And then the loan, then wouldn't you know, that's going to pay $14,000 per month for 12 months. So essentially what we've done is we've created a penalty for a year because of that gift, and then we use the loan then to pay the nursing home during that year of ineligibility. So if we do all this, we then apply as of, and then in our previous slide, we said that all these transactions happened on July 28th. So we then apply for Medicaid as of August 1. That starts the ball rolling. That gets the penalty clock going because of those criteria Lou just went through. We then the penalty would then run for that year. So the penalty would run from August 1, 25, essentially until August 1 of 26. The note pays at the same time. And then August 1, 2026, 1 year from now, comes Bob's on Medicaid.
So people who have done note planning, this is one of the solutions. The rule of halves transfer. Trust me, the numbers are never this easy or even. And the process of collecting information, collecting data, you miss one income source and you've got a bad calculation, your note payments are going to be off.
Yep.
So you have to make sure you have full and accurate data with regard to income and assets. And then you can go to work in terms of spend down. How do we create shelters, whether it be burial accounts or fixing up the home? How do we spend down as much as possible Frank mentioned paying your attorney, never a bad thing. So your lawyer's fee comes right off the top in this calculation. And once you get down to the amount of excess resources, you plug in this formula. We actually have software that's been developed that does this calculation, provides the promissory note and all the tangential documents that go along with it. So it's something that we've done a good amount of planning and Medicaid applications for. And so what has been achieved?
So when you go back and you look at, well, what happened? Why did we do this? It's because we saved Bob a pretty substantial amount of money, right? We put 168,000 in his trust. We allowed him to keep 30,000 in his bank account. We prepaid his burial, and then we bought him some personal property right off the top. So all in, if Bob came to us with 400,000, we saved 220 of it. So we saved more than half, and we go on Medicaid, where then his income would then be used to pay his nursing home. So really, there wouldn't be any real continued burn on his financial stuff that he does have, unless something very unanticipated happens. So, and then the trust is there to avoid probate, kick everything back to his beneficiaries free of the court process. So it's not only saving quite a bit of stuff for Bob, but it's also then doing some additional planning, making it nice and easy for the family when the time comes.
Yes, and avoiding probate is a key because estate recovery is part of the New York State plan. They are going after every estate that they can find that has assets. So the question becomes, Frank, what is the definition of the recoverable estate?
Essentially, it's anything that goes through probate, right? It's the person's probate estate. And then that's assuming that they're not survived by a spouse or a disabled child. So there are some exemptions to the clawback, but there are not many. So we as planners, we like to avoid probate for our clients whenever possible in general, because it makes things a lot easier for our clients and their families. But when you have a Medicaid case, you certainly want to be avoiding probate, because if there isn't an exception, anything that goes through probate, Medicaid's going to have the first crack at.
And the trust is a very, very functional and useful piece of the planning. If there's only one child involved and that child is okay just receiving outright gifts, we sometimes do that as well. But we believe the trust, keeping the assets secure, avoiding probate and having access to them, they can be invested inside the trust, they can grow inside the trust, and it becomes a very useful tool. So for married couples, there is another option. If only one spouse is applying for Medicaid and it happens to be Nursing Home Medicaid, chronic care, then we have other planning available to the family, Frank.
Yes. So we have the numbers, right, that deal with specifically with the community spouse, one for income, one for assets, and then ultimately we have the spouse of refusal and what that entails.
So if you remember the $74,820 or twice that up to $159, and then the income allowance for the spouse, those are the numbers we're talking about here. There used to be very good ways to increase these allowances, but those ways have become extremely hard, and it almost has to be the healthcare costs of the community spouse to get it increased.
Right. So your minimum monthly maintenance needs allowance for that community spouse, again, is $3,948 for this year. Again, up slightly from where it was. So the nice thing about this is if the spouse by themselves does not make $3,948, they get shifted amounts of income from their spouse to bring them up to this number. So that's the nice thing, is that while it's still not a lot of money, I think it puts a lot of people in better circumstances than they would have thought otherwise without it.
Right. And we have the CSRA. I'm going to skip over that.
Go ahead.
We've talked about that already, and get to spousal refusal, because this is something in New York, not all states, but in New York, is still a legitimate planning strategy.
Yeah. So essentially it's the well spouse signs a statement saying, I, spouse of person in nursing home, hereby refuse to contribute my income and or my assets to the cost of care for my spouse. And if you do that, when Medicaid does and reviews the application, they only look at what the Medicaid spouse has. Whatever the well spouse has is not counted against the Medicaid spouse for eligibility purposes, which is really great, because that allows us to get Medicaid for somebody when they may not have been able to because of the things that their spouse has.
And it's a situation where you still win even if you lose, because you saw the Medicaid average regional rates. Albany County, our area here, around 14,000, but the actual cost is closer to 18,000. So if you do a spousal refusal and the individual goes on Medicaid and Medicaid starts paying 14,000, the recoupment against the assets of the community spouse is at the $14,000 rate, not the $18,000 rate. And so these are the rights that the state has, Frank, in a spousal refusal.
Yeah, I mean, the biggest issue here, and this is why, again, it's good to work with a qualified elder law attorney when doing all this kind of work, is because when a spouse refuses, that unfortunately opens them up to a potential lawsuit by the county providing Medicaid for the spouse. So whether that county will pursue an action or not, that's to see, right? Not every county litigates every case. Some counties are more litigious than others. But ultimately, if the county does want to seek rights against the community spouse, they are allowed to do that. That goes hand in hand with doing the refusal. But as Lou said, there usually are benefits to do all of this because Medicaid gets repaid at a lesser rate than would have been happening privately. And that's if a lawsuit's even sought. Not every spousal refusal case results in a lawsuit. It's something that you have to educate your clients about if you're working on our side of it. Clients have to understand kind of what they're signing up for, but the benefit is Medicaid and for lesser money, even if they do.
So qualified legal counsel is important. Getting good legal advice is important. Our firm is available to clients throughout New York State. We do virtual consultations. We love in-person consultations. We have multiple offices in New York where that can be accomplished. And we offer a free consultation. So if anyone is out there that needs counsel, you have clients that need counsel, we're happy to be that elder law counsel that fulfills this need. And it's something that we're very, very happy to do. And want to just give you a heads up before we go to questions. The next Medicaid Monday, as we mentioned, the home care situation.
Yeah, so we've got about a month of time to see if there were any more news shakes out from all the new developments, but we'll be back on August 11th to talk about kind of what all this means for home care. With the 380L change that we mentioned already, and then kind of what else is going on.
And looking down the road, what's the future of home care and the look back period? What's the future of the Medicaid Asset Protection Trust? What's the future of a state recovery? These are all things that in my 42-year career have been attacked very aggressively by New York State. They have backed off that. They had enough litigation. There's a class action lawsuit regarding Medicaid trusts. But we think that all of those things, once that $1 trillion cut hits and the New York State budget is shrinking, we think all these things are going to come back on the table. So it is so important for people to plan now and get out in front of this. And that's the formal presentation. We do have some questions teed up. We're going to stay on till about 1 o'clock. But if you have to go, we understand. Thank you for joining us today. We hope you can come back on August 11th for the home care presentation and the new home care rules.